I've taught constitutional law for 16 years, and one of the areas that most interests our students and me as well are the areas of privacy and sexual orientation, and of course dealing with issues of liberty and equality in that way. We'll have to do that another time, but I don't know how I'm going to do what I'm doing with one paper in the time limit I've got. Nancy MacLean, as you've heard, has written a fascinating paper in which many large themes lie entwined within 30 short pages of text. She's told us that the paper is a preview of sorts of a much larger work on privatization that she's exploring presently, and that's quite evident. Even within the limits of this paper, we see 6 or 7 major themes are introduced first to the conservative intellectual responses that she has dredged up from the archives involving some key correspondence between the then young James Dale Kilpatrick and Leon Duer, who were key figures behind the massive resistance to Brown and school desegregation in the infamous Prince Edward County case. We learn of the far larger political project they had conceived in the middle of what they must have known was going to be the defeat of that time, a project not only to preserve in some distant future some measure of school segregation, but to employ and redirect popular unhappiness with federal desegregation decrees to advance a far more expansive program of opposition to New Deal programs and government generally. We see, third, how the strategy of privatization, which these early conservative strategists conceived, was deliberately and carefully forged not only to begin dismantling the public schools themselves, but eventually to remove effective government control over large areas of public life in favor of private markets. We are introduced to a range of semi-familiar conservative foundations and legal advocacy groups and learn ominously how the particular policies they have articulated to our knowledge over the last 2 decades might be seen as tightly woven into a carefully sequenced set of political economic objectives. And we see these conservative groups aware of their weakened numerical position in the late 1950s and early 60s begin to reach out for allies, first among Northern Catholics and then conservative Protestants in the South and West, and eventually and most remarkably, and it's where your paper kind of doubles back appropriately, Nancy, on African Americans. They do so, as we say, as you said, with the sort of teaser issue of school vouchers, but they are intent upon gathering first support for the voucher movement, but more broadly to shift that toward support for privatization, generally the elimination of government involvement in many areas of post-New Deal public life. So MacLean nicely brings her vast landscape back to the original starting place by meditating on how a strategy conceived in rural Virginia by whites who refused to let African Americans even attend their schools and would rather shut those schools than have desegregation, how such a strategy could ultimately transmogrify into a policy that began to attract progressive black educational leaders like Howard Fuller in the 1990s and 2000s. One observation and then 2 comments, and then I think I'm done. The observation, it seems, is this is so reminiscent of the political economic sort of project in the tradition of C. Vann Woodward's Strange Career of Jim Crow. You all remember the story of C. Vann Woodward telling us the conservative whites who found themselves in the late 1890s politically outnumbered and making a momentous decision to reassert political control by playing the race card. They had lost control because of the economic distress of the early 1890s and the rise of the populist fusion alliance between black and white. Their strategy, of course, had been to use vehement racialized appeals to white solidarity, claims of black depravity, and drive a wedge between the working classes of the 2 races, and then use law, state law, to physically separate the races, to disenfranchise African Americans, to disempower them, and to re-cement their own authority. Now, crucial to that strategy, of course, was the acquiescence, the complicity of the Supreme Court of the United States and federal law. And that, of course, came, as we know, in Plessy in 1896 and the Cumming case in 1899. What's striking, of course, as the challenge that faced Kilpatrick and others in 1959 was that although they sought the same kind of reassertion of control, the Warren Court, the Supreme Court of the Brown era, was by no means under conservative control and had not shown itself either in Brown 1 or Brown 2 or in what I think of as the gunfight at the OK Corral for school desegregation, the 1957 Little Rock case, Cooper versus Aaron, that they were willing to back down. And they forced President Eisenhower reluctantly in the 101st Airborne with its bayonets unsheathed to do their judicial will. So how could white conservatives build a strategy in that climate that would turn defeat around and eventually bring disdain for federal control? So not only so that some shred of racial politics of Virginia could be maintained, but so that an even broader claim for local authority might prevail over what was then very powerful federal governmental authority. The challenge, of course, is more problematic because there was no real option to the racial appeals of the 1890s. And there certainly was lots of despicable racial rhetoric and demonic language and fierce appeals, but it was all plainly going to be unavailing in the crucible of the courts. The answer that MacLean gives us is several-fold, a longer-term project that she suggests began with the promotion of the public school voucher and other programs. Indeed, that was certainly promoted at the time in the Prince Edward County case. What they did is close the schools, give everybody vouchers, and give tax rebates to people that, in fact, used their private funds to go to private schools, white segregated academies. But that was overturned by the court in 1964 in Griffin versus Prince Edward County. Indeed, the court said that we see behind this racial intent, and therefore you may not use vouchers. You may not use tax rebates in such a way. So they had quite a project at their hands. What they did in part, and this picks up, Robert, a little bit of the thought that you made, that they conceived something more fundamental, an attempt to shift from a rhetoric of equality and toward a rhetoric of liberty. America has always sort of moved between the poles of liberty and equality.